I know there's some great conversations going on, but I've got a committee meeting I need to get started, so I'll ask everyone to take their seats.
How are you? Good. Good to see you.
I'm going to call to order the Anchorage Assembly Committee on Regulating and Taxing Cultivation, Manufacture, Commercial Sale of Marijuana in Anchorage, probably the longest title of any committee out there. And we'll go around with introductions. Prior to that, I would like to inform we're looking at some ex officio ad hoc members to this committee. And one of the individuals that Chairman Traney and I have had a conversation about and have asked to join the committee in that capacity is David Schulte. So he'll be joining us at Bruce. I'm sorry, Bruce.
You're thinking of my brother.
Yeah, I'm thinking of your brother. So Bruce will be joining us at the table as an ex officio member of the committee. With that, Todd, I'd like to begin with you, and we'll introduce everyone sitting at the table that'll be a part of this work session.
I'm Todd Sherwood with the Municipal Law Department.
Erica McConnell with the Crime Planning Section.
Ira Herman, Abe Ernie Hall. Tim Steele.
Elby Gray Jackson. Julia Tucker, Assembly Council.
Pete Peterson, Assembly.
Ernie Hall.
Dick Train, Assembly.
Bruce Schulte, Coalition for Responsible Cannabis Legislation.
Amanda Moser, Clerk's Office.
Thank you. I want to, or not want, I'm going to give Erica McConnell the majority of this meeting today because that's going to be our topic, is going to be zoning and land use. But prior to doing that, I'd like to do a quick update. We did do our first town hall meeting on Saturday, February the 28th. We had, I thought, a pretty fair attendance. I was very appreciative of assembly members that came in addition to the committee to be there and participate and listen to the input we've got. A very informative meeting with presentations from our legal, law, our clerk, and our land use department planning. We will be scheduling another one in about 3 months. I'll get a definite date set at that time. And prior to turning this over to Erica, I would add too that, I think we've been eternally optimistic that maybe we would have a little more out of the state legislature at this point in time. But I don't know that they're making a lot of headway real fast. It appears that every bill that gets introduced kind of hits a roadblock. They're back at it again this week. And we're now down to under 28 days in the session. So it may end up that we end up at some point handling a lot more of this at a local level than we may have anticipated to begin with, depending on whether the state actually goes and gets some legislation passed, and then depending on what happens with the ABC board in the writing of regulations. And of course, they're on kind of a hold till we get to the end of the legislative session and see what the legislature does that leads to the regulation part of this. So do we have anyone from the police department that may want to give us a quick update? I think not. Legal, Todd, you have anything this
I have a couple things I can address. We have been continuing to follow what's happening in the state legislative committees, and Mr. Wheeler and myself have both testified. He's done more than I have. There are just a couple issues I was going to bring up that we've addressed recently. One concerns the number of plants in a household, and I think, as everyone knows, under ballot measure 2, it talks about 6 plants for personal use per adult. And so then you have the concern of, if there are 8 adults, does that mean you get 48 plants in a single house, which obviously raises concerns. One of the problems they've had in Colorado, and it's somewhat more on the medical marijuana side, for reasons I won't go into, but getting from what's called the gray market into the black market. Anyway, and Mr. Schulte, who's here, testified at this hearing also, is there was discussion of having, and again, this is what Denver has done, is sort of an absolute 12 plant limit per household, no matter how many adults are living in there. So if you have 3 adults or you have 4 adults, 12 is your limit, then the extra adults would just have to work it out between themselves. And it does amount to a lot because our sergeant case here said, right, 6 plants in a year, you can get 9 pounds of marijuana. If you're, yeah, roughly. If you're halfway decent at your job, I guess, for all the stuff. Anyway, then I asked planning to do a little research for us, and it turns out in Anchorage that there are 1.77 adults. In other words, less than 2 adults on average per household. And so we continue to recommend 12 plant limits per household across the board, and believe that that's reasonable because you're rarely going to have more than 2 adults anyway in a household. There was a brief legal analysis by one of the legislative attorneys that was concerned that it might violate equal protection. We don't see that as an issue. In Denver, the 12 plant limit has not been challenged in any way, shape, or form. Doesn't mean it couldn't, but it's been in place for over a year now, and that has not been challenged. So what happens with this remains to be seen. There's a proposal to make it 24 plants in the legislature. Our push has been 12 and/or leave it up to municipalities. Because generally, our push has been give the municipalities maximum amount of flexibility. The other issue that has come up was a proposal, and this came from Mr. Schulte. Again, as everyone knows, Anchorage passed an ordinance on public consumption of marijuana because there wasn't a definition for public in the state ballot initiative. The legislative committee, again, is working on that. One of the proposals from Mr. Schulte's organization was to add language that said it's unlawful to consume in public except on the premises of a marijuana establishment operating under a state or local license or permit. And we sent a letter in to Representative Tilton that addressed that issue. We're opposed to that because as it reads, this means that you could buy at a retail establishment, buy your marijuana and stand there and smoke it, which is similar, in our opinion, to going into a packaged liquor store where you can't drink it, but you could buy it, pop it open, and drink it right then and there. Our proposal was they take our language that we used, which was it's unlawful to consume in public except as permitted by ordinance, regulation, statute, or permit. And then for special events in certain places, you might get, be able to get a permit to consume on those premises, but it wouldn't be an across-the-board thing without any real licensing or regulation. So those are the 2 things I had to present.
Thank you. Any questions? Yes. Mr. Peterson and then Ms. Tucker.
Thank you, Mr. Chairman. And I was wondering if you've had any thoughts or taken a look at what the change in some of the laws could cause a case to be brought because we have the 1975 Raven versus State of Alaska case that's sort of been, the case that has been ruling, the rulings on marijuana have been following that case. And so now that we're changing things, are we going to get to a point where someone could say, hey, Raven should still be the superseding law in this case? And are we going to, there's going to be a test case that is coming up in the future, do we think?
Well, Mr. Peterson, through the chair, I'll do what probably an attorney shouldn't do. I'll opine off the top of my head. I used to be a prosecutor. I used to prosecute marijuana cases, and I've read Raven. In fact, when I was a prosecutor, I was in Kenai, and I had one case. I can't remember what it was, but it was just kind of interesting because Erwin Raven was the defense attorney on the other side. So I met him many years after 1975. In any event, I don't see that as being particularly an issue. My opinion is that what ballot measure 2 did was, in a sense, for personal use, it expanded upon Raven and really gave some definition to it. That wasn't necessarily the intent. Raven, ballot measure 2 was intended to legalize commercial and personal use because all Raven really spoke to was the privacy clause of the Constitution And the Supreme Court said the privacy clause of the Constitution protects the right to have a small amount of marijuana in the home. The ironic thing was, you read it literally, anything you did to get that marijuana in your home was illegal. You know, as Cindy Franklin often says, it had to magically appear there somehow. Arguably, maybe you couldn't even grow plants there, you could just have it, however it got there. And then a later case said 4 ounces was kind of the cutoff. But ballot measure 2 makes it very clear, you know, that you can have the 6 plants and you can transport up to an ounce at a time, things like that. So I don't see that as being an issue. I'm sure there'll be plenty of other legal issues, but I don't see that as being.
Great, thank you.
Ms. Tucker?
Thank you. Todd, in our attending those presentations in Colorado, and this is a question about the 12 plant limit, which I understand that's just a strict limit, but in the somewhat related to that, perhaps in some of the jurisdictions in Colorado, the local jurisdictions, my understanding is that they chose through zoning to say that you had to have that anything over 6 plants was a commercial business, so that they drew a line, not about whether it was legal to possess or not, a number of plants, but that for residential neighborhoods, if you had the right to possess it, but if you lived in a single family or some other residential neighborhood, then you needed to comply with the zoning ordinances about having businesses there. If you had over 6 plants, whether you intended to sell it or not, they just did that. How does that tie? How do you see that tying in for Anchorage?
Well, through the chair, and I'm aware that we did hear that some of the small communities did that. I didn't find that to make a lot of sense, because essentially what they're doing is saying, it's residential zoning, if you're gonna have over 6 plants, then you have to have a commercial license, except they're never gonna give a commercial license. So it's basically a flat 6, and it doesn't really address the kind of the common sense fact that, you know, as we've seen, we have pretty close to 2 adults per household. So it doesn't really deal with that issue at all. And maybe it's something that would require further study, but it didn't really make sense to me. I think the 12 plant limit was much more of a clean cut thing, and the fact that there's been no challenge of it in Denver, to me, is the good news on that.
Anything else, Ms. Tucker?
No, thank you.
Ms. Mosher?
Through the chair, I just wanted to speak on what Julia is talking about. I think she's referring to the example in Boulder, Colorado. And it was maybe not specifically zoning, but they had the licensing requirement for more than 6 plants. So if you had more than 6 plants, you would have to get a license through the city. And they, in Boulder, have the dual licensing, which is something that I know we've talked a little bit in this committee. I think might be something to consider for Anchorage, requiring both the state license and the municipal license. And that's how they were able to address some of their concerns. And when the presentation from Boulder was specifically from the Boulder Chief of Police and the campus, Colorado University, which is in Boulder, Chief of Police, and they spoke about their concerns with the fraternities and stuff like that, and so they addressed the 6 plants.
Okay, thank you. Thank you. Anyone else? Mr. Steele?
Just an observation. It seems to me that if somebody is growing it for their own purposes, if they're starting with seedlings or seeds, they're going to try and germinate, there's going to be more than 6 plants to start with if they prune and go through everything. It just seems to me, I saw some rationale where they said so many a certain size, so many another size, and that type of thing. But I'm just thinking in terms of a function, if somebody is really growing it for their own use, they're going to be up against the law if they're actually sprouting more than 6 plants at a time. Anyway, just an observation.
Mr. Attorney?
Just, Mr. Schulte, as an ex officio, please join us if
you want to be a part of the discussion.
I was just waiting for any questions. I definitely have some thoughts on that, but.
Going to bring them forward. Go ahead, sir.
Okay, Mr. Tree, I think it's a valid point. You know, if you're growing from seed, you might not all the seeds are going to be successful. On the other hand, a lot of folks do prefer to start from clones, and I've heard a number of people have actually approached me saying, "Hey, is there going to be room in the state's regulatory structure for people who just want to grow plants and sell clones? They don't even want to harvest the mature product." And I think that there may well be a business model for that, and that I think that would be very attractive to some people because then they can go buy a plant that's already 4 weeks old. It's healthy. They know what strain it is. It's clearly going to thrive if they don't mess it up.
Right.
And they can bring that home and grow it and perhaps even produce their own clones from it. There's no guarantee of that. Now, I don't know that it necessarily speaks to the legal question that Mr. Scheer was talking about, but it's another factor to this whole conversation.
Very good.
Thank you, Mr. Chairman.
Okay. Chief Mew, I see you've just joined us. You have anything that you'd like to share with us at this meeting in regards to the law department or enforcement? You're welcome to join us at the table.
Mr. Hall, thank you very much. I
As
just
you're
walked in the
sitting
door, I
in,
don't
you're
even know
Chief
where we are in
Police.
the conversation.
We're just talking about the number of plants that people can have, but we'll give you every meeting an opportunity for any concerns or issues that you'd like to share with us.
Why don't you continue with the discussion, let me catch up with you folks.
Very good, not a problem. Anything from the clerk's department, Ms. Mosher, at this meeting?
We have no update at this time.
Okay, very good. With that said, Ms. McConnell, you're the star today, so the rest of the meeting belongs to you, and we'll come back at the end and give the chief a chance if he's got anything that he'd like to share with us.
Thank you, Mr. Hall. My name is Erica McConnell. I'm the manager of the current planning section. We work with Title 21, and so we'll be responsible for processing ordinances that amend Title 21, which is what we will have to do for the regulation of commercial marijuana. I have prepared a PowerPoint. Unfortunately, I'm told the projector and the computer are not connecting, so I hope everybody has a paper copy. There's a couple left over there. I'm intending to just expand on the very, very short presentation I made at the town hall meeting. What we're doing at this point is more talking about decision points and the various types of decisions that could be made. We don't have very many recommendations at this point. I think there's going to be a lot of information that'll come out of state law and regulation that will help us start to make recommendations. So there's a few recommendations we have in this, but most of it is just identifying choices and decision points that will have to be made through ordinances. So if you look at the, not the title page, but the first page, the overview, our four main questions are, what are the uses that we are regulating? Where in the community should these uses be allowed? What type of approval process should these uses go through? And what standards should be applied to each use? So turning the page, here we have our first choice. Are we going to look at all of the issues relating to marijuana through the lens of existing uses in code? So for example, a grow operation could be considered commercial horticulture. Commercial horticulture is a use that is already defined in Title 21. It already is allowed in certain zoning districts by certain approval processes, and may or may not, depending, I don't remember about commercial horticulture specifically, but may have some use-specific standards. A research laboratory would cover the testing facility. The retail sale of marijuana in a store would probably fall under the general retail use. The other option is to create new uses for the however many uses we identify, and there's four very clear ones: your grow operation, your processing and production, which would include both extraction of THC and any sort of production of edibles or tinctures and that sort of thing. your testing facility, and your retail store. So those are 4 very clear uses. There could be others depending on what comes out of state legislation, or, I didn't think about today of somebody who's growing for sale. That would probably, or who's growing to sell plants to other people, although I suppose that would just fall under a grow operation. The benefits of developing new uses in the code rather than going under the existing uses is that we have a lot more ability to both define what these uses include and don't include, and then create use-specific standards for these uses and target them to districts. So it gives us a lot more flexibility. So this is the first recommendation that I would make, is that we should develop new uses rather than fitting the various types of marijuana operations into our existing uses. I would note that some of the ordinances I've looked at for local communities in Denver and in Washington State have fit their marijuana uses into their existing uses. One question that would come up, and I'm sure this is something we'll be discussing with the legal department, is whether growing your personal 6 plants that you're entitled to under the statute should be a listed accessory use in the code and just allowed by right in all the districts where we allow residential uses, or whether we don't really need to address that in Title 21. So that's a question to be answered. So the next 2 pages are just a visual of what the code might look like if we created our new uses. The next page, this is a screenshot of the table of contents of Chapter 5 in the new Title 21. Chapter 5 does list the uses. So we could create a whole discrete section just for marijuana uses, or it could be listed just above there where you see commercial uses, definitions, and use-specific standards. It could come under, we could create a new subsection under 2105.050 for marijuana uses. And then the page after that would be an example of what the use table would look like with, the uses listed in the table, and then you'd have your zoning districts. And you won't see anything filled out here, but I'll get to that in a minute. So, turning the page again to the heading that says, where should these uses be allowed? So when we examine this topic, we look at what are the characteristics of each of these uses, and what are the impacts of each of these uses, and therefore what kind of zoning districts do they make sense in. And I think we would all agree that from what I understand about what commercial grow operations look like, particularly because they have to be out of sight of the public and because of our climate and the amount of light we get, that these grows will be done indoors, in warehouses, and that makes them kind of an industrial use by nature. It's just a big warehouse building. You may have issues with odor. So these would be things that we would probably end up recommending to be limited to industrial zoning districts. Your processing and production, again, where you're extracting the THC using, whatever methods end up being allowed by law, whether it's a flammable solvent, whether it's CO2, whether it's water. That is a type of manufacturing process. You do have potential chemical uses, and then if you're producing, edibles, then you're going to have some sort of manufacturing of food. So this is again, and you may also have odor issues there. So again, this is more of an industrial type use and would probably be geared best for the industrial zoning districts. Your testing facilities, this is going to be basically a laboratory. We'll have very few off-site impacts. You're not going to have a great deal of product on site. You're not going to have your odor issues. So this would be something that could probably be done both in industrial districts and in your general commercial districts, most likely. But and again, this is this will all be worked out. And then your retail stores are, of course, your general commercial uses. We'd be recommending that they go in commercial districts. I think some of the questions are, would we allow them in our downtown districts? And would we allow them in our smaller neighborhood serving commercial areas such as the B1A district or the B1B district? I know some communities in Colorado have made very specific rules for their Main Street areas, or I know Breckenridge, which is a relatively small town, has kind of a main street that's kind of what what is distinctive about their community, and they've had a lot of discussions about whether or not they want to have retail marijuana on their main distinctive street. So that would be a discussion that we would have. So turning the page, I've shown a screenshot of the same use table that I had earlier with just some, general thoughts of what makes sense in terms of your grow operation and your processing and production being allowed in your industrial districts, your testing facility allowed in your B3 in your industrial districts, and your retail store definitely in your B3, but would you put them in your other districts, your residential office, your smaller commercial districts, B1A, B1B, or even in your R4A, which is your kind of mixed use, which allows both commercial, retail, and residential. So again, this is not necessarily a suggestion, it's just thoughts about what might make sense, and I'm sure this will all be discussed in a great deal more detail. Some associated issues, of course, we do have separate use tables for the Girdwood community and for the Chugiak Eagle River community, so those tables will have to be also updated. We like to keep the uses consistent across the community in terms of definitions and for the most part standards, but definitely in terms of definitions. But where each community feels that they think it's appropriate to allow these uses, we've generally worked with the community for them to determine that. So we would want to go and work with the Girdwood community about where do they see these uses in their community, and with the Chugiak Eagle River community for Chapter 10, where do they see these uses in their zoning districts there. There is also an accessory use table, so if we identify, again, like I talked earlier, whether personal grow is a listed accessory use or not, are there other accessory uses that we would identify and need to put in that table? And then, it's possible there may be other locational restrictions that would be addressed through use-specific standards. Maybe there's utilities would say, well, we really can't support a grow operation in this particular area. I'm just hypothetically, I don't really know if they would say that or not. Or if we did say we don't want them in the center of, well, it could be addressed through use-specific standards. So I didn't think of a lot of examples, but that could be done.
Yeah. Erica, Pete.
Yes.
I'm not sure if you wanted to wait till we got to the end for questions or.
Fire away.
Okay, and this is maybe a question that we is going to probably discuss further on as we go along. But when we had a presentation, the Assembly did maybe a month ago, that showed us what our remaining industrial lands that we have left for still to be developed. And I'm worried that we're going to be using a large percentage of those industrial lands for marijuana growing operations. And one of the reasons that I believe this initiative passed was people have been growing marijuana in their basements and spare bedrooms for decades. And some people have been saying, well, I don't want people growing marijuana in my neighborhood. Well, people have been growing marijuana in your neighborhood for 40 or 50 years already, and you just they're not aware of it. And I think for us to get to the point that we can reduce the black market or eliminate it, we have to allow people that have been traditionally growing in their home to be able to become legitimate growers in their home after it becomes legal, or now that it's legal. And so that's just a discussion I think we are going to have.
So I think it's Senate Bill 30 talks about different licenses, and one of the proposals in that bill, like the last time I looked at it was probably 2 weeks ago, so I don't know if it's changed, but there was a home grow, like a commercial home grow license. So if that becomes something that is available in the municipality, maybe that would be a separate use that we would list and define. It would probably have a limitation on it, I would guess, and then could talk about allowing that in residential districts, if that's the will of the legislative body. So again, I'm trying to deal more with the framework here rather than there's the specifics. I think, like you mentioned, are very wide open for discussion and determination.
Yeah, I was actually in Juneau and spent a couple hours watching the Senate Finance Committee dealing with SB 30. So, and they've actually worked on 18 amendments one day when I was watching that, and so I'm a little familiar with that bill.
Mr. Trini.
Eric, as we go through this process, could you show you is, right now for alcohol, we have community councils, they have to go to community council. I want the same thing for marijuana. Want to treat it just like alcohol, so it's built in the process, we're gonna have to go to community council for approval too.
So my next couple pages will get to that
Thank you.
kind of issue.
Okay.
Sorry I
Mr.
jumped the gun.
Okay, Mr. Schultz.
Thank you, Mr. Chairman. I'm not sure if there's a question as much as an observation. What Ms. McConnell referred to, I think SB 62, the regulatory bill, has what you described, the home grow license. And I would agree that has great potential to allow those black market operators a smooth transition into a legitimate industry. So with due deference to the residents around them, I think it would be good strategy to try and give them a path to take that home grow illegal operation, make it legit, but not beyond the point where it begins to intrude on the neighbors' peace and ownership of their property. But that is something that was in SB 62, and we were supportive of that and encouraging that direction. But we also suggested that maybe that should be handed off to the regulatory board so that they could work on it more closely in the greater time that they have to do it, and in conjunction with the various municipalities, because I think there's great potential there.
So if that does become something that the municipality decides to approve or license in some way, we'll fit it in, we'll define it, we'll put use-specific standards on it, we'll put it into the use table, it'll be indicated what zoning districts it would be allowed in and what kind of approval process, so it'll fit right into the structure.
Great.
Okay, so moving on to the next page of what type of approval process should these go through, and this gets to Mr. Craney's point. So there's a lot of options, and I listed options that I'm 99% sure you're not going to go for, but I just listed them there just so you understand all of the options. Right now in the code, there's four and a half options. So you have your by right option, which means it's allowed by right in the district. They don't have to deal with the planning department at all. You have your site plan review option, and this is the kind of half because it really is two separate processes. One's administrative and one's a public hearing process, but they're both a site plan review. Then you have your conditional use process, which is the decision-making body for the conditional use is the Planning and Zoning Commission, and there is a public hearing involved with that, and there is, under the new code, a requirement to go to a community meeting, which is usually the community council meeting. And then the fourth is kind of how we deal with alcohol, which is this. In the old code, you think of it as a conditional use for alcohol. We've renamed it in the new code. It's the same process, but we call it a special land use permit for alcohol. For alcohol. So should the assembly want to model marijuana approvals the same way they handle alcohol approvals, we would create a special land use permit for marijuana, and then we could discuss what's the procedure to come to the assembly, and if the desire was to make sure that they go present to the community council, that's certainly something that could be put into that procedure. The considerations as you're deciding what the approval process should be. So first of all, not every use in every district needs to have the exact same approval process. Some uses in some districts, it's easier to do them, and in other districts there's a more lengthy process, usually depending on what else is in that district and what are the impacts on the surrounding uses. So some uses might be more difficult to do in residential districts. You might have to go through a conditional use to do it in a residential district where it's permitted by right, or a site plan review in a commercial district. So it's not, you don't just have to pick one thing, although you can. I think the concept of dual licensing is really important when you're thinking about this issue. If there's going to be dual licensing, then you're going to have a licensing approval and a land use approval. Who's going to issue the license and who's going to issue the land use approval? They could be the same body, which brings some efficiency to the process, or they could be separate bodies because the body that has the most expertise to deal with the licensing issues may be different from the body that has the most expertise to deal with the land use issues. So that'll be something you'll want to think about if we go the dual licensing route. Mr. Trainey's point, the amount of public involvement that you want to have for each particular use in each particular zoning district. And of course, the, legislative body's comfort level with, if you decide that it's not going to be the assembly issuing the land use approval, your comfort level with who you're delegating that authority to. Moving on to the next page, what standards should be applied to each use?
Erica, just.
Erica,
Yeah.
just one other thing you were talking about, them having to go to community council.
Mhm.
Let's build a framework so they actually have to physically attend the community council. Because some liquor licenses, make sure they do it like May, June, July, when the community councils are not meeting, the bulk of them. So I get that complaint from community councils all the time.
So the way the new code is structured is we require a community meeting, and the reason we call it a community meeting instead of a community council meeting is that if they're doing their public outreach in the summer and the council isn't meeting, they are required to mail notice to the 500 properties that are closest to their site and hold a community meeting. So in the spring, fall, and winter, we encourage them to use the community council as the meeting, but we don't let them get out of having a meeting with the property owners if the community council doesn't happen to be meeting.
Okay, thank you.
Ms. Tucker?
Erica, through the chair, I had a clarification I wanted to ask you about. When I heard the term dual licensing, I was thinking that referred to not one license for conditional use and one license, business license, but in fact was specific to business licenses. That is, dual licensing would be one license may be required by the state, and a secondary business license, which we don't now have for alcohol, would be issued on a local level, but that in either, whether the state and city go with dual business licensing or not, there would be a separate land use, conditional use process.
So you're assuming there will be a conditional use process, and I guess what I'm trying to say here is that's not set and decided yet.
Well,
But-
or a
so-
land use process.
Yes, there will be a land use process.
Yeah,
And so
land use
I didn't
process.
mean to imply that the land use process would be a licensing process.
Okay.
What I meant is the state will issue a license. The city may issue a license. So if the city does, that will be the dual licensing, but then the city will have two decision points on any particular operation. It'll have the business license and it'll have the land use approval. With liquor, really all we have is the land use approval. And so you end up with and I'm actually going to talk about that in this slide a little bit too. You end up with issues wrapped into the land use approval that really aren't related to land use. For instance, the requirement for all servers and sellers to have a TAM card. That's not really a land use issue, but because the city doesn't issue a business license for liquor establishments, we have to wrap any issue that we have with the establishment into the land use approval. So, yeah, I didn't mean to imply that the land use approval was
No,
a
and
license.
I may not have heard you correctly. I just wanted to
Sure.
just make sure we were. I
Okay,
understand.
so what standards should be applied to each use? So again, however many uses we end up with, assuming we create new uses, each one can have its own standards. So we're not talking about the same standard for a grow operation that you might have for a retail store. Some of this will be determined by state law and regulation. So for instance, I think in one of the bills, and I don't know which one, did talk about a separation distance. So if the state law requires that, we're going to enforce that. If the state law doesn't require that, that may be something that we want to look at on a local level. So I think it's really hard to say what kind of standards we might want to recommend until we understand what's come out of state law and state regulation. And then, again, back to the dual licensing issue. If the city is going to issue its own business license, what are the regulatory topics that ought to be associated with the business license versus the regulatory topics that ought to be associated with the land use approval? If the city does not issue a license, it'll be like alcohol, where we have to wrap all of the issues that the city may have, whether or not they're land use related, into the land use approval. Moving on to the next page. These are just some examples of standards that some communities in Colorado regulate, and I actually brought for you local regulations for the city of Boulder, so you can kind of look at, they kind of took everything to do with marijuana and put it in one section of code, so it's more than just zoning, but it's kind of interesting to look and see how very detailed they got in certain issues. But anyway, so some standards might include separations from other uses or districts. You have maybe separation from similar uses, like you don't want to have too many stores too close to each other. Some communities do that. Separation from schools, separation from addiction treatment facilities. You know, you can kind of run the gamut on lots of things, just a few things. And, you know, we've already put together some maps that look at separations from certain things, but when that's more firm, we can certainly produce more maps to show what those separation distances look like in terms of, you know, if you're separating from parks or from schools, we can show you that buffer around each park or school to see what that looks like. One thing to keep in mind there is, do we have the right data? You know, are we being told, so say you're going to separate from churches, are we being told every time a church goes into a strip mall, do we know about it in order to, you know, create, to evaluate the separation distance for a new licensed facility that may come in? Some other standards include a maximum size of the establishment, limits on hours of operation, more restrictive sign regulations than maybe for other general uses, security requirements, types of operational requirements. I would think that some of the, again, back to the dual licensing issue, some of the operational requirements would certainly fit more under licensing regulations than they would under land use regulations, so as that plays out. And then, you know, can you do drive-through purchasing of marijuana? Will we allow marijuana deliveries, phone and internet sales? And you know, again, you can make an argument that those are, not the drive-through issue, but the others are licensing. So we'll have to work that out. On the last page, just some other issues to keep in mind. I believe at the last meeting, Cindy Franklin said that the state was not going to put a limit on the number of licenses that they were going to issue. So if that's the case, does the city want to put a limit on the number of licenses that they're going to issue? Some communities do, some communities don't. If we decide we want to, how, you know, what do we base our, we have to pick a number. We're going to issue X number of retail store licenses, X number of grow facilities. How do we determine what the right number is? I don't have a good idea for that right now, but that would be something we'd have to discuss. And then if you have a limited number of licenses and you have more people who want those licenses, how do you choose who gets those licenses? Enforcement, right now, I am not aware that the code enforcement, I'm not talking about fire enforcement or anything else like that, but land use code enforcement doesn't really go out and do any regular inspections, but we did hear in Colorado that they would schedule once or twice a year inspections, and then they would sometimes have surprise inspections. So if we want to do that, is that something we need to put into code? Some communities have very specific standards on what, you know, if you do these violations, your license is revoked. Again, maybe that's going to be put into licensing issues. But if it's like alcohol and we don't have a license, do we want to go? I think personally, it's pretty cumbersome to revoke a conditional use, and you get into, you know, property rights and entitlements and things like that. But would you want regulations that make it easier to revoke a if it is a conditional use process or an assembly permit? Do you want standards that make it easier to revoke it if the operator turns out to be a bad operator? And then, as you'll see in the Boulder regulations, they've defined a lot of other things besides just the uses. So do we need more definitions so that we're clear about the terminology that we're using in code? So that's the framework that I wanted to share with you. Clearly, there are, you know, hundreds and hundreds of details to be worked out, but I hope that I've clearly explained kind of where the decision points are, so that we can move forward as we learn more about what the state's going to do. The last thing I wanted to mention to you is that we have put together a staff working group. So the kind of permitting, planning, building, fire, police, code enforcement, and utilities. So we're sitting down and we're just talking to educate ourselves and be prepared for when, we're really starting to be asked to make recommendations to you. So I just wanted to let you know that that is happening.
Okay. Questions of Erica? Good. I've got some. One is one of those trivia questions that always pops in my head when I hear a presentation. With churches and malls, I guess it's never dawned on me, what do we do when we got a liquor store in a mall and a church wants to move into a mall?
The liquor store has rights to continue.
Okay.
But, and then there's rights about how long the conditional use is valid if they go away. So I think it's 6 months, although I'd have to check on that, where if they go away and another one wants to move in, the conditional use is still valid. But if the conditional use expires and a church has moved in after the liquor store had come in, then a new one can't come in.
Okay. Good. Things that I'm curious about, and I've got to say, Erica, the department has done really good work here. I mean, questions that honestly hadn't popped into my mind yet. But here's my main thing is I want to try to get an arm around this, and I don't need it this meeting, but maybe the next meeting. I'd like to get an idea, a timeline on when we will get some of these questions answered. I'm also curious about who all the planning and zoning department is going to include in this. How involved will P&Z be into this process?
Well, when we develop an ordinance to amend code, the Planning and Zoning Commission reviews and makes recommendations to the Assembly on all changes to code. So unless you write into your ordinance, notwithstanding the section that says this is supposed to go to P&Z, we're not sending it to P&Z, it would go to P&Z, they would review it and make a recommendation to you.
Okay.
And that's just standard for ordinance changes.
Okay. What I'd like is to see if you can come up with a timeline for me, because I want for us to be ready no later than May of 2016. I mean, it's imperative that we have all of this worked out. So I kind of wanted to go there and work back in regards to you're getting it drafted, referring it to P&Z or whomever it needs to go through, because I can't honestly think of a reason that we would circumvent any of the process that works for any other industry coming into this community. And also questions in here that you're not going to deal with. I mean, when I'm looking at signs, we've got a sign ordinance that everybody works with within the community. Is there any reason that this industry would be any more restricted than any other industry? I can't think of one off the top of my head. But what I want to do is, as soon as we get an idea of that, then I'll know any specific things that maybe this committee is going to need to deal with directly, because once it goes through you run it through whatever committees or commissions that have to hear it. We do the public notice, and of course everybody's just going to get an opportunity for input when it comes before any of it comes before the Assembly for approval through the public testimony process. So we're really not recreating anything here. I mean, we've got due process we follow for any other industry that comes in. I don't know what would make this one honestly any different than those. But if it would be possible to kind of develop a timeline for us so we've got an idea of how this is going to flow through the process.
Sure.
Okay. And I'm also curious if you can give me an idea about once you do get it written, who you would be referring it to, P&Z, or if Title 21, the Assembly Title 21 Committee, I'm assuming will be taking a look at parts of this as well.
So changes to Title 21 are required by code to go through P&Z before they come to the Assembly.
Right.
It would be, if P&Z wanted to ask another body to look at it, I'm not sure who they would pick. The Assembly certainly has the authority to ask other bodies to look at it. I am not aware that changes to other portions of code, say Title 10 for licensing, have any kind of lower level review bodies that it goes through before it would go to the Assembly. But, the Assembly Title 21 Committee, of course, would want to look at it
Mm-hmm. But P
Yeah,
and
I'll certainly
Z,
think about that, but I can't
Right.
think off the top of my head that there would be anybody besides P and Z in the committee.
okay, so P and Z would definitely be one point that the public would have the opportunity to go in and do public testimony prior to it coming to this body.
Yes.
Okay. Good. Anybody else?
I was just wondering about, like Natural Pantry. Natural Pantry wanted to sell spices or sell marijuana, packaged marijuana, or whatever it is. Would they have to go through this whole process, or do we include particular uses in particular zones?
So they would be a retail store,
Yeah.
so it all depends, and they're right now in the B3 district, so it all depends on, presuming retail stores are allowed in the B3 district, what's the approval process? And if it's assembly, special land use permit for marijuana that comes to the assembly, Natural Pantry would have to, get, and assuming dual licensing. So I mean, there's so many assumptions here, but assuming those things, they would have to get a license from the licensing authority, whether it be the clerk or the assembly. Boy, that's,
Hmm.
that would be an issue that we should probably
They're gonna
write
change
it
something's
down,
gotta be
farmer's
done.
market,
That's been
yeah.
mentioned across.
Okay,
so
Erica,
since
thank you.
Saturday.
Great,
It sure
great
does.
presentation. Chief Mew, anything pop in your head in the meantime?
Yeah, a couple things just popped in. Thank you. I didn't know I was on the agenda. I thought I was just showing up to listen.
Oh, you will be at your department. Either you or Deputy Chief Fanning will be on our agenda every meeting.
Well, I've been out of town for a couple of weeks, and I know the legislation has been moving through Juneau, and so I'm not up to speed on where it is now, but I know it's changed quite a bit along the way. So that's one thing we're tracking. Erica referred to it, and I wanted to maybe highlight it a little bit. We are trying to put together sort of an unofficial level this time, an interagency team that could think about doing the inspections on these different facilities if we come to have them. I think our impression, I think we sort of agree on this, that if we leave it up to the ABC board or whatever that morphs into, we may not get the level of inspections that we're comfortable with here in Anchorage. I mean, we'll inspect us, but I know the ABC board right now can't get out to the alcohol establishments nearly as often as they would like to. And so if Anchorage could do its own inspections and monitor its own industry, we think that would be better for us. And I sort of think of what happened with the Merrillfield Inn when we had responsibility for it for a brief period of time. And we didn't know anything about running a hotel, so we put together a group of people, went out there because there were health concerns, there were structural concerns, there were safety boiler concerns and fire code concerns, there were concerns with criminal element that was in there. So, we had people from code enforcement, health, police, fire, municipal attorney's office, a bunch of people, I'm probably leaving some out. That approach might be the way to get started here too. We had a team of different folks that knew different aspects of how these facilities might be regulated. I think that group is already starting to sort of form up and kick things around. Of course, it's not official, it's not funded, it's not institutionalized, and there's nothing to inspect right now. But what I think the delegates to Colorado heard was a community approach like that is a good one, and we sort of took that to heart, and we're starting to think about how that might work. And at some point in time, I think the idea needs to be blessed and institutionalized in time for us to deal with whatever it is we inherit.
Very good. Anything else?
Things seem to be going fairly smoothly. We're not writing a lot of marijuana tickets yet. Written a few for smoking in public or consuming in public, but not many.
Very good. Thank you. Public comment. Anyone in the audience have comment? Okay. Our next meeting is scheduled for April 23rd. Hopefully the legislative session is going to be over by that time. And once that's over, then I suspect that we'll go back and re-engage the legal department. You'll have a whole lot better idea about what's going to fall on us. Of course, we'll do the same thing with planning and zoning. And Ms. Mosher, when you're ready to have a shot at a program, which could be the next meeting, let us know what the clerk's office is doing to prepare to deal with the all of a sudden this deluge of license that will be coming in all at one time, probably. Mr. Schulte, David, Bruce, whatever. Welcome to the committee. We're adjourned.